Welcome, everybody. Yes, we have been talking about you, but we've only been saying nice things, so it's all good. We want to welcome you to the Family Law Update, the one we have every year with Agnes at the Provincial Training Conference. I realized as I was thinking about what I've said about her in other years, that she always used to bring candy, the saltwater taffy, and we're going to miss that this year. One of the many reasons we'd rather be in person. But we're happy to have Agnes here. Agnes runs a family law practice, has for many years. Her firm is Saltwater Law. She's also, I don't know, Agnes, last year you said you were on the Family Law Committee of Trial Lawyers Association and the Family Law section of the CBA.
Still am. They haven't kicked me off yet, so.
No, good. So anyway, I'm sure most of you know that Agnes is a great resource. Comes with many persona, but again, it's a webinar, so we may miss out on that this year. But we're happy to have you, Agnes. Before you present, we want to acknowledge that we're presenting, or I'm working in the shared territories of the Coast Salish people, the Musqueam, Squamish, and Tsleil-Waututh nations. That's an important part of acknowledging in our work. I think most of you by now know that we want to have the questions in the Q&A rather than the chat. And I think this time I will watch them as they go along and let Agnes know, because she's got the PowerPoint to watch. And we'll just go for the next couple of hours. Okay, thank you, Agnes.
Thanks so much, Lois. It's always great to see you all, which I can't see you, which is so sad. My most favorite thing about doing the conference with you all is actually get to connect with you, to see you. So I'm missing that for sure. And now Lois has just put a stock photo on, so I don't even get to see her moving. Oh, there you go.
I can stay and keep you company.
No, I'm just kidding. I'm kidding. You can. That's the point. When you're on video, you know, people get to see all your facial reactions and stuff. I should tell you one story before. Well, first of all, I'd like to say, people ask, my friend and I were talking about what do we say when people wish us happy Thanksgiving. As you know, of course, that memorializes Columbus arriving in the new territories. And I say, you know, these days I say that I'm grateful for the Indigenous peoples of Turtle Island, particularly here, the peoples of the Squamish, Musqueam, and Tsleil-Waututh nations, to allow me to work and live in their territories. And that's what I then say in reply to people. Mm-hmm. So, but I appreciate that we all should acknowledge that we are on the ceded territories of the Coast Salish peoples, and anywhere in the province. I also work in the Sechelt Nation and also the Tsimshian Nation up in Prince Rupert. So I'm always grateful to be able to be here with them all. A funny story, I was just talking about video, is, you know, now, of course, the courts are using a lot more. Well, some courts are using video. BC courts are finally getting into video, but Alberta courts have been using it a lot. And so I was at the equivalent of a family case conference with a judge there. And the judge said, I just want to tell counsel, and I think she meant me specifically because the other lawyer was pretty far off the camera. She says that because I'm seeing you on video, I can see every facial expression you make. Because I pretty much, at one point, I think the man said something, I was just like, oh my God. And so I was like, so I gave her a big smile. She said, yes, just like that. And I was like, okay, one has to remember that. Apart from dressing appropriately, including pants. Pants are good. Anyway. Oh. Yeah. So I'm really excited to be with you here today. I have I went through some of the cases. I didn't get a chance to go through as many as I wanted to in terms of the whole picture. There's always a lot. But I first wanted to start with just discussing, why is my thing not moving? Here we go. Practicing family law in the era of COVID. Now, I understand there's a session around the actual practicalities of what's going on in the court, so I won't really talk about that. And I won't really talk about what the courts have decided on these areas of parenting arrangements and child and spousal support, because we're kind of like, we're not over COVID, obviously, but we've moved into a different phase where I think some of these cases won't come up as much again because we have a fair bit of precedent around them. Of course, you remember the big issue around parenting arrangements, particularly the parenting time and schedule, and what then became the denial of parenting time, was whether or not parents had to follow the orders or agreements related to the parenting schedule when there was COVID. And generally, courts say you must, if they're court orders, you must follow court orders. And of course, the general test around whether or not a parent could deny parenting time without doing so wrongfully was whether or not there were medical issues that made the person higher at risk for COVID-19, either that person or the children or that the everyone's family. You remember we were in a much smaller bubble before, then we got a little bigger and so forth. And the other part was whether or not the other parent was following the recommendations of Dr. Bonnie and other health officials regarding COVID-19 to ensure that he or she limited the chance of infection from COVID-19. And I'm sure you were all involved in a lot of those cases at the time where it was pretty heady and people were having to run to court to claim denial of parenting time, or some people were able to make arrangements. And so I'm not sure if they've all ended, but certainly we don't have as many of those cases coming up now. And secondly, because the court wasn't really running at full capacity, you can come into court, it made it a little more complicated to bring those matters. The second area was, of course, child support and spousal support. And I know probably a lot of you were dealing with your clients who weren't getting child or spousal support. And that was at a time, of course, when lots of people were being laid off or losing their jobs altogether and weren't in a position to pay child and spousal support. And you might remember for several months, the court had no process to actually bring issues of child and spousal support because those weren't considered quote unquote urgent at the time. And then later they moved into a process where you could do some by written submission to sort of essentially an interim order around child and spousal support. And now I think we're back on track so that any applications to vary child support, spousal support, or cancel arrears or deal with arrears will go through the normal course as it has been through the courts. Normal being the application, the notice of motion. Normal, not normal as in attending in court, because of course we're probably still doing more telephone and video. I don't know if, anyway, out where you are, if you're doing video, but Robson Square is finally getting into doing MS Teams for family matters. So the one area of COVID litigation that I think is still might be relevant right now, although I think maybe a lot of these cases will have already been dealt with, is COVID in school, right? Kids going back to school. And there aren't any reported decisions in British Columbia that I know of. Oh, sorry. And this is as of last week or so, because I had a matter before the court involving COVID in school. So the cases, there's a couple of cases out of Ontario, and this is probably the most cited case, Zanatti and Spence from Judge Akbarali of the Ontario Superior Court. So the determination of whether or not whether children should be attending in-person learning or online learning should be guided by the following factors. And this is a key thing because most parents will say that, want the court to make a decision. But the court has said here that really it's not for them, the court, to determine whether educational plans or return to school are appropriate. It's really for the government at large to determine whether or not school plans are safe and effective. Because, as Judge Akbarali says, the government has access to public health and educational expertise that is not available to the court. And the court's not in a position, especially without expert evidence, to second guess the government's decision making. And because the situation and the science around the COVID-19 pandemic are constantly evolving, it's the government and the public health officials who are better positioned with the new information to be able to determine whether or not a plan for school is appropriate and whether it needs to be modified in order to keep children safe. So that's a big part of going to court and saying, court, usually we say the court, you need to make those decisions. The court is sort of abdicating that part of the responsibility to say, you can't, some parents will say, well, we don't trust what the health officials are saying, or, There are, as you know, lots of petitions out there by parents or by other teachers saying, these measures in place right now aren't sufficient. And the court is saying it's not for us to judge that. If the government and health officials say that it is safe, the court has to accept that it is safe, and to trust that if it becomes unsafe, that the government and health officials will take proper steps. So that's the first major factor in terms of whether or not a judge will determine whether or not children should be in-person school or online learning. The second part is in determining whether an educational plan is in the child's best interest. Now, this is also a key thing for the court, because it's not realistic to expect or require a guarantee of safety for children who return to school during a pandemic. In some cases, parents want 100% assurance that their child will not be infected by COVID-19, and there just is no 100% guarantee. Even if children are out in the general public, there's no 100% guarantee. There's always some risk. The question is, what's the level of risk that's acceptable? And this is a pretty morbid statement. The pandemic is only over for those who did not survive it. It's a pretty morbid statement. Anyway, so there is always some risk. So a parent who says, I don't want my child in person school because I need 100% guarantee that my child won't get infected with COVID-19 by attending school, won't succeed on that argument. So on the terms of what is appropriate, what are the factors to be used to determine the best interests of the child? These are some of the factors. There are 5 of them. And again, it's not limited to them, but these seem to be applied, generally cover the issues that are needed to be dealt with in determining whether or not it is in the best interest of children to go to school. Now, first of all, there is a presumption that children in school is a good thing. Children having access to an organized educational plan, plus also the social aspects of school, is a good thing. So that's where it starts from that premise. So the first factor is that the risk of exposure to COVID-19 that the child will face if he or she is not in school or is in school. So, excuse me, that's one of the factors. And again, that may be looking at what kind of health situation it is for the child. If the child has no underlying medical condition that makes the child more susceptible to COVID-19, then the risk is considered to be low. Again, similarly, whether the child this is the one. The risk is whether or not the schools themselves have taken proper measures to ensure the risks are lower. Here is what I was referring to, whether the child or family members in the child's home are at risk of COVID-19 as a result of health conditions or other risk factors. And again, there has to be actual medical evidence of the risk that a child would be in terms of COVID-19. And as I mentioned, I recently did a case and the judge found that there wasn't sufficient medical evidence. It was quite vague as to what the medical condition was that would put the child at risk. So the child in that case the order was that the child would attend in-person school. Whether the child faces any risk to their mental health, social development, academic development, and psychological well-being from learning online. And this is what I was talking about, is that the presumption is that children in actual in-person school is beneficial to children. So whether or not a child being out of a social circle, essentially, or not in school with qualified teachers, for example, would affect that child's mental, social development, or academic learning. This is a factor that they also talk about where schools have hot lunch programs or other support services for children. So it's a lot, I think they're referring to children who live in poverty, and that not having access to, lunch or other supplies in school has an effect on their social development. 4 is the child's wishes, if they can reasonably be ascertained. Of course, that's more for older kids. And then finally, the ability of parents with whom the child will be residing during school days to support online learning. including competing demands of a parent or parent's work or caregiving responsibility or other demands. So this is also the ability to actually, I mean, those of you who've had to do homeschooling or online learning, my clients tell me it's a lot of work and you need to do a lot. It's very demanding. So if a parent doesn't have the either educational capacity to do that or the time, primarily, if the parent has to go to work, then oftentimes that the child will the result will be that the child will be in person school. And it's not sort of a response for one parent to say, well, I'm working at home and I can do this, so I can have the child the whole time. That generally won't trump the child going back to school. And I just suggest on this that there are some of these same factors probably can be applied to whether or not a child should be in extracurricular activities, such as in soccer, band, or going to camps and things like that. These are some of probably the factors that also might come into play. So that's all I want to say about COVID and schools. Moving on, this year, the Supreme Court finally has spoken on a family law matter. It has been quite a while, and I don't know how many of you have heard of this case because it's a huge case in the family law realm, and it comes out of British Columbia. This is a case called Michelle and Graydon, 2020 SCC 24 September. I can't remember the exact date, 19. And one of the key points is that one of the interveners in this case was West Coast LEAF, the Women's Legal Education Action Fund, and I think their involvement was quite critical. If you read the essentially the complementary decision issued by Madam Justice Sheila Martin, which I'll come to. So what does this case have to do with? So the general facts are that M and G, so these are their last names, were in a common law relationship and are the parents of A, who was born in 1991. So G was to pay child support from 2001 and was paying some child support. But child support was terminated by court order in 2012. In 2015, then, the mother applied to retroactively vary child support for a period between basically the beginning of separation, April 2001 to April 2012. That's an 11-year period to reflect the husband, the father's actual income. So there was issues of whether or not he actually had properly disclosed his income at the beginning in 2001 and subsequent years. This matter first came before a provincial court judge in BC, and the father was ordered to pay $23,000 in retroactive child support. When it went up to appeal to the Supreme Court, that judge allowed the appeal, not on the basis of whether or not the father was a bad dude by not disclosing his income properly, but on the issue of whether or not you could bring an application when a child is no longer a child of the marriage under the Divorce Act or the Family Law Act. Now, because they weren't married, only the Family Law Act applies. But what the issue was the Divorce Act talked about the application being brought while the child is a child of the marriage. The difference is the Family Law Act doesn't say that, but we'll get to that in a second. So it's just that whether or not you meet this threshold of, and essentially the courts in British Columbia have also ruled that unless the child is currently a child of the marriage, you cannot bring any child support application. So because the child had aged out, for example, like they finished university and were no longer, and then you find out later that the ex has, actually was earning like 3 times as much income, there was no capacity to go back and get retroactive child support. So the Court of Appeal upheld that ruling. So here's the revolution. When we got to the Supreme Court of Canada, the Supreme Court of Canada allowed the appeal. And the majority decision was written by Justice Brown, who actually looked at the difference in the wording of the Section 152, because of 152 of the Family Law Act, which deals with varying of child support orders and child support orders. And Judge Brown said that Section 152 authorizes the court to retroactively vary a child support order, irrespective of whether the beneficiary is a child at the time of the application, and irrespective of whether the order has expired. Because you remember, in this case, the order had ended in 2012. To hold otherwise would defeat the legislative purpose and create a perverse incentive for payer parents to avoid their obligations. Because I'm sure you have, well, I have clients who will say, if I just be quiet and do nothing and don't disclose, and my ex doesn't actually come after me, I'm safe once the child ages out. And that's, not that there's an obligation to pay child support, but that's certainly what payor parents could say. No more. So applying the DBS factors, and this is factors about, I hope you all know the case DBS is the main case that deals with retroactive support. The court noted that the child experienced hardship due to her father's neglect of his child support obligation. The court noted that the father had failed to accurately disclose his income at the time of 2001 order was made. And so that was blameworthy conduct, warranting an order for retroactive child support. So remember, blameworthy conduct is one of the factors that needs to be considered. And the court found that the mother's delay in seeking retroactive child support was reasonable in the case. And that is from the majority, which was 4 judges. And then there are concurring reasons. These are the more exciting ones, to be frank, from a feminist perspective, from Justice Martin. And Sheila Martin, just so you know, used to be a professor in University of Calgary and on the court in Alberta. But she's been a long time, actually, well, she had been a long time member of LEAF, and she argued for LEAF many of their interventions in relation to sexual assault cases. So she's got a good grasp on the feminization of poverty and, issues in family law. So these are some of it's a really exciting read in terms of I think, first of all, Madam Justice Claire Leroux de Bay would be excited about the language here. And I think Ruth Bader Ginsburg, rest her soul, would be as well. So I'm just highlighting a few of the things that Justice Martin said. There's a lot more. It's so fulsome. It's amazing. It really takes into account the context in which a parent may or may not pursue retroactive child support, and it really looks at the best interests of children in child support orders. Which, as you know, when we talk about child support, it's just this formula, right? Is devoid of the context, unless you're talking about shared parenting or split parenting. You might consider a bit of the context, or hardship, right? But generally, you're not talking about those things. But the court makes it clear, particularly the 2 concurring judges, which are Justice Martin with the Chief Justice Wagner, that child support obligations arise upon a child's birth or the separation of their parents. And retroactive awards are a recognized way to enforce such pre-standing obligations and to recover monies owed but yet unpaid. So that it just highlights the obligation that a parent has to pay child support, right? It just stresses it, which is very important. I mean, we all know about the obligation to pay child support, but lots of parents operate, as I said, on the basis that if you're quiet enough about it and nobody does anything about it, then you're off the hook. I'm talking about the payor. And then, of course, for the recipient, as you know, a lot of times, particularly women, will not pursue child support because, 1, they want nothing to do with their ex. Sometimes they don't want them to know where they are. And secondly, they know that if they pursue child support, the response will be that their ex will pursue shared parenting of the children or primary care or something like that. And so oftentimes women do not do that because they don't want to be engaged in that litigation with their abusive ex. So here's the exciting part. So here's the next, oh my God, listen to this, read this. Section 152 of the Family Law Act, the child support provisions, promotes the best interests of the child, enhances access to justice, reinforces that child support is the right of the child and the responsibility of the parents, encourages the payment of child support, acknowledges there are many reasons why a parent may delay making an application, and here we go, recognizes how underpayment of child support leads to hardship, and contributes to the feminization of poverty. Justice Martin goes on to say, preventing historical claims for child support under Section 152 of the FLA also ignores how family law calls for an approach that takes into account the broader social framework in which family dynamics operate. Gender roles, divorce, separation, and lone parenthood contribute to poverty and place a disproportionate burden on women. Whew. I mean, this came down the same day I was doing a presentation with my colleague my friend Todd Bell on child support over the age of 19, and we spent part of our presentation having to talk about this case because it's so revolutionary, and it's so. And I'm just touching on a few of the comments that Justice Martin made, and because it's concurring reasons, and also Justice Abella and Karakatsanis also concurred in the result. Nobody is opposing this particular framework. This gives us leave to use the words of Justice Martin, to use her analysis, and to then push forward in support of our clients when we have retroactive claims, or even going forward on claims for child support, and to address the issues of delay, address the issues of blameworthy conduct, and address the failure to disclose. And so it's a really principled response, taking into account the real social dynamics that operate. And this we haven't seen for some time. So this is really exciting. Anyway, I go on about this case because it's very exciting. There is another case that the Supreme Court is considering out of Ontario Court, Colucci, similar kind of thing, except the father is trying to cancel his arrears. But again, it's about whether or not he can bring a retroactive claim to cancel his arrears. So that should be heard, I think, sometime in November. And again, West Coast Leaf is intervening in that. So hopefully, once Colucci is dealt with, we'll have a nice principled approach to dealing with retroactive child support, moving further from what DBS has, because DBS has been quite difficult oftentimes for women to apply in terms of dealing with like the reasonableness of their delay in seeking retroactive child support, or that 3 year. Oftentimes it's talked about you basically can go back 3 years. We'll see how far the Supreme Court went. That's like from 2015 all the way back to 2001. That's a 14-year period. Not sure what the court would have said. I mean, obviously, if the amount was a lot higher, I'm not saying 23,000 is not a lot, but the court would also, as you know, consider whether or not the payor can pay that. That's part of the factor that does get considered as well. Okay, so after that excitement, I'm just going to move on to what the allocation of parental responsibilities. I have a number of cases that I saw that I found really interesting around one parent trying to restrict another parent's parenting time or parental responsibilities, and how the court has dealt with that. So I've got, I think it's 3 cases that I want to talk to you about this next round. This first one is from Judge Doulis, and this was out of Smithers, I believe. It's called NMB and KDB, 2020 BC Provincial Court, 291. So they're 2 kids, 9 and 7 years old. And the parents were more or less having a shared parenting regime when they separated. Now, it's uncontested that shortly after separation, or while after separation, that the father struggled on and off with a cocaine addiction for, it's about a year and a bit, as you can see there. The mother, NMB, sought 2 things. One, that all parental responsibilities be allocated to her. And she also sought supervised visits on the basis that she said the father is an addict who is untruthful about when he is using. And she also wanted to restrict the father's parenting time until he proved to her satisfaction he had stopped using drugs. So this case, I can't remember this case, I think this is the case, I forgot to write this down, but talks about the cycle of addiction, right? Where, sometimes they'll be sober for some time and then get back in their addiction a brief time. Sometimes they'll be longer in their addiction. And basically these cases I'm going to take you to are the court sort of saying, you cannot be so punitive to parents who are dealing with addictions, mental health issues, or other issues in their lives. And so here, this is what Judge Dula says, is that what the court has to look at is the best interest of the children only. And I'm just dealing with this in considering the allocation of the parental responsibilities. The court must focus on the best interests of the two children rather than the interests and the rights of the parents. The judge says she suspects that the mom's intractability in these proceedings is driven by her hostility towards NW, who's the father's partner, or her desire to punish the father. And in these circumstances, Judge Doulas found that it's in the best interest of the children to, this is a key one, to alleviate rather than sanction or exacerbate the power imbalance between their parents. And so the judge ordered that the parties share equally all parental responsibilities for the children. So that, I think, is the key line, is that her concern, Judge Doulas, was that if she gave the mother all the parental responsibilities, that she would use it in a way to really block the father out and probably continue and punish the father however she could. So if you are arguing against the allocation of parenting responsibility just to one parent, I mean allocating all, not the final decision making, but you can then think about the issue of whether or not it will exacerbate the power dynamics by doing so. I mean, obviously we deal with a lot of cases that it's clear that the allocation of parental responsibility should just be with one parent when a parent is not around, or there's a lot of family violence and there's no real chance of cooperation. But I think Judge Doulas says is that I think the finding, as you'll see when you get to the next slide. Oh, that's not it. Sorry, that's not it. Sorry, that I think the Judge Doulas was saying that despite the father may go in and out of his cocaine addiction, but he had been taking steps to deal with his issues. And so he shouldn't be basically wiped out of his children's lives by granting the mother her application to have all the parental responsibilities. Because once you do that, it's really hard to get them back. Just as we know, once you terminate guardianship, it's pretty impossible to get your guardianship back. So that's why the courts take those things quite seriously in terms of whether or not they grant the orders. A next one, I'm just calling this sort of a restriction on parenting time. And these are a couple of cases I want to take you to. This is from the Supreme Court, Mr. Justice Nathan Smith, called CDA and PRB. So the mom was seeking to review the parenting order, and she was seeking primary residence or parenting time. So in 2019, December, the master made an interim order that the child reside primarily with the father, with the mother having parenting time in public. So not supervised, but in public. And throughout her life, the mother suffered from anxiety and depression and from an eating disorder. So you can imagine that the father tried to take advantage of this. And then you'll hear what Mr. Justice Smith says. So the master, though, was also cognizant that, the mother was taking steps to deal with her mental health issues, and said that if the mother puts together a better and more extensive pattern of counseling and self-awareness, understanding what's going on with her, what the master calls an unfortunate mental health issues, then the parenting time is subject to review. So the master understood that, didn't make it, as you know, if you make a final order, to change a parenting order, you need to have a material change of circumstance. But the master left it more open and saying, look, if the mom does what she needs to do to support her health and get healthy, then this should be reviewed. The father pounced back with, before Mr. Justice Smith, saying he wants supervised parenting time. And what does he do? He pulls out all her clinical records that she had to disclose, and he basically uses them against her. Right? And this is what Judge Smith notes. The mother, having had significant insight in recognizing her need for treatment and appropriately seeking treatment, now finds the records of that treatment being used against her. So you can imagine that Mr. Justice Smith did not think highly of what the father was trying to do to the mother. And so the judge says that the Justice Smith didn't agree with the father, that the onus is on the mother to provide a report confirming she's capable of parenting. because that's not what the bar was set by Justice Smith. But sorry, the master. The master just basically said, if you can show that you are following a treatment plan, you're taking care of your health, you're addressing your issues, we'll review. And as you know, to try to get some report confirming you're capable of parenting will involve an expert report, which you're going to pay for, and the costs are quite significant. Here, Mr. Justice Smith says, the mother suffers from anxiety and depression. Those are conditions that cannot be minimized, but they are all too common in society, and their presence in itself cannot be grounds for denying or restricting parenting. Most important, there is nothing in the clinical records to suggest her condition poses a risk to the child. And this is important for all of us who, oftentimes our clients are struggling with mental health issues or addictions issues. And we know they get pounded with those issues by their other parent. And this is a good case then to use where Mr. Justice Smith says, you don't get to do that. It's not okay to do that. And it's not just that the parent has to show that they don't have anxiety and depression, because, as we say, lots of parents have anxiety, depression, other mental health issues, and they parent their children. They parent their children very well. And so in and of itself, having a mental health issue isn't enough to restrict parenting time. And what you need to look at, as he says, is a risk to child, and risk being to the child's physical, psychological, and emotional health. That's sort of the key underlying in section 37.3 is the language there. So then the judge, the father moved to, that the child is having nightmares after spending time with the mother. And the judge, this is the funny, I don't mean funny as in haha, but the judge notes and says, okay, it's virtually impossible to weigh and fully appreciate the context of hearsay statements of a 2-year-old, because, this is the father saying it or the father's family, particularly one who spends most of his time with adults who are clearly hostile to the mother. So when the mother was having her visits in public, the father and his family would be hovering around her. And that's what Justice Smith is noting. And Justice Smith notes that the child has not had a normal relationship with his mother for a third of his life. There's a need for some caution, but on the balance, and considering the section 37, best interest of the child factors, it's in the best interest of the child to restore his relationship with his mother. And this will unlikely happen if all of her parenting time is supervised, and even less so if her time is at locations where their interactions are being directly monitored by the father and others close to him. So the judge makes an order, well, first of all, addresses supervised access by saying that there needs to be evidence of exceptional circumstances, because it is one small step away from complete termination of the parent-child relationship. Now, there are a number of cases that say this, and I'm sure you all know that. What the court needs to then ultimately weigh is the child's right to relationship and the risk of harm, among other factors. But those are the key, that children have a right to have a relationship with their parents, and also, but to be safe from harm. And so Mr. Justice Smith adopts Master Elwood's approach in a case that I'm going to refer to next. Mr. Justice Smith ordered that there be graduated parenting time for the mother and unsupervised. Actually, I think it starts a little bit supervised and then, unsupervised. And then because the judge knows that this child is 3, so that there are 16 more years of co-parenting ahead for these parents. And so it's important not to basically, he trusts that the mother will continue on her path for healing. And obviously, if something happens, and then the father can come back to court. So, and this is really important because it's similar to the COVID-19 thing. You can never have absolute guarantees that a parent won't relapse. I mean, it's quite common, but that doesn't mean that the parent can't parent. And I mean, we deal with this a lot in child protection cases, you all know, where the ministry just, every little relapse, they just pound the parent, right? They don't get an opportunity. It's part of that cycle where, people are in their addictions, they're out of their addictions, they're in, and it varies. So I think this is a great case in terms of cautioning people and other judges not to just go, alcoholism, mental health, just and pound that parent who is dealing with those issues. So I mentioned the case by Master Elwood. This is this goes a little further in terms of that the father had suicidal ideation. So there's two children, 4 and a 1.5-year-old. And the mother wanted the father's parenting time to be supervised until the matter could be dealt with at trial. So this is an interim application. Just to be clear, there had been no trial set, so we didn't even have a timeline as to when that would happen. The father has a history of depression and suicidal ideation, so it predates the separation. But unfortunately, he also attempted to commit suicide by overdosing following separation. So that was a very significant incident. The father argues that evidence is insufficient to show any risk of harm to the children and that he is doing well and receiving appropriate and ongoing treatment. So he's seeking unsupervised parenting time and also Section 211 report. So here's an interesting question that the court, Master Elwood, addressed. Is threatening to commit suicide family violence? Okay. So Master Elwood says, I have no difficulty accepting the mother's proposition that a threat to commit suicide may constitute family violence, particularly where the threat is used as a form of psychological weapon in a family dispute. You know, the cases where one party says, if you don't do this, I'm going to kill myself. And that is, you know, psychological torture. And also particularly if the parent actually relays that to the children somehow. That is what Master Elwood would say is a psychological weapon. In this case, though, or not in this case, sorry, Master Elwood goes on to say that it would be a mistake for the court to label every disclosure of suicidal ideation as family violence. And again, this is taking into account social context of people. To do so risks stigmatizing people who struggle with mental illness and suicidal thoughts as violent or abusive. Telling a spouse about suicidal thoughts is not in and of itself abusive. The context is important. So this is a really good case for ensuring that, you know, to bring up to a judge where one party is sort of, again, raising things about, oh, the mental health or suicidal dependencies or alcohol dependencies as a way just to denigrate the parent and also to try to use it as the leverage to take children away from a parent. Context is important. And also acknowledging that people who suffer from mental health issues or are considering have suicidal ideations aren't in themselves violent or abusive, except to themselves. So Master Elwood continues, says, characterizing every disclosure of suicidal ideation as family violence would also risk discouraging those who need help from seeking that help and deprive their spouses of important information. As the mother herself argues, former spouses and medical professionals must rely on self-reporting by a suicidal spouse to recognize a potentially dangerous situation. So in this case, the father had disclosed that he had attempted suicide to the mom, or it was known. He didn't hide it. I think he was taking the hospital, so it was known. But this, Master Elwood said, the mother's position would force the dad to basically hide the information. And not only from the mother, but also probably from, most likely also from his care team, his treatment team. Further, Master Elwood says, there's no evidence the father used the statements about his suicidal thoughts as a form of psychological abuse. His disclosures began before the relationships broke down, and there's no evidence he used disclosures as leverage or retaliation against the mother. If anything, the father knowingly weakened his position on parenting arrangements by disclosing these thoughts to the mother. There's no evidence the father talked about suicide in the presence of the children, with an exception of one telephone call where he was talking to the mother and the child was nearby. And there's also no evidence of a pattern that the father was exposing the child, meaning the 4-year-old, to statements that would scare her. So again, this is a really good case to rely on if your client has mental health issues and the other side is trying to ramp that up to say that your client is not a good parent or can't parent. So the court is making very clear, because you have mental health issues or addictions issues does not make you automatically not capable of parenting your child. In this case, again, supervised visits should be ordered. The mother insisted on supervision when the father was discharged from the hospital. So the father had to agree, otherwise he would not see his children altogether. And to be clear, there was no court decision about supervision being warranted. In this case, the master said that the father's recovery is promising, but he's not able to conclude that the father's fully overcome his depression that drove him to attempt suicide. The question of whether he's fully clear of the risk of another suicide attempt can only be determined, if at all, at a trial with full benefit of full testimony, cross and expert evidence. So the master presumes that the father remains a risk based on the factors identified in February 2019 when he attempted suicide. However, though, the question isn't about whether the father's at risk of attempting suicide, but rather whether, without supervision, the father poses a risk to the physical, psychological, emotional safety and well-being of the children. Master Elwood says, in my view, it's a large step from the recognized risk of repeat suicide attempt to a risk that the father would seek to take his life or endanger the safety of his children while they are in his care. And that step is too large for me to take on the evidence. So in this case, Master Elwood did not order supervised visits, that the visits had to be all supervised. And he notes a number of factors that other people had cleared him. The father was an ER doctor, and he was cleared to work back in the emergency room and being responsible for the health and safety of vulnerable persons. And it had been a year since the incident, and there's no evidence of any behavior by the father that put the children at any risk. So again, this is another good case. And there's one more, and I realize the time, so I'm going to, sorry. The best interest of the child is protected by allowing the father's unsupervised parenting time, as long as the father essentially continues his health monitoring program, get regular updates from his treating psychiatrist, and make full disclosure to the mother about his health circumstances. One last one, again, this was an interesting one. So this was a 6-year-old child. The parties lived in Victoria, I believe, and the mother had struggled with alcoholism after the child was born. She completed a residential treatment program. In 2017, she started to work as an escort out of her home to supplement her income as a hairstylist. Now, the father found out about this and then told the landlord about the escort business, and the mother was evicted. And I should say, Mr. Justice Meyer was not impressed by the father doing so and considered that inappropriate to have contacted the landlord. The father also called the ministry, which led to the mother having supervised visits. So the question was whether or not the mother's visits should continue to be supervised, which is what the father wanted. So this is the court saying about being an escort. In my view, working as an escort is a personal choice, which the mother was and is able to make. Her choice of work as an escort does not necessarily impact her ability to parent the child, so long as she maintains an appropriate separation of this activity from her son. The mother at the time said she was no longer working as an escort, but in fact was working as a hairstylist in a separate commercial space. So the judge then went on to say, if she was operating an escort business out of this commercial space, which he doesn't find was happening, this would not necessarily qualify as a material change of circumstances, justifying a reconsideration of the child's parenting arrangements. Now, at the time, the previous order was that the parents shared the parenting of the child. Something more would be required, indicating that this activity put the child at risk or otherwise impacted the mom's ability to care for him. So the judge noted, though, that she previously, in working as an escort from her home, where the child would come and stay, didn't adequately consider the obvious risks of bringing clients into her home that she shares with her child, even when she was not there. She, as in the child's, he was not there, sorry. But the mother admitted her mistake, and so the judge accepted that. Regarding the mom's alcohol use, the judge said that the father has to satisfy the court that the mom was not only consuming alcohol, but was doing so in the presence or was intoxicated while the son was in her care. And the court was not satisfied that that was the case in the evidence. And we have lots of cases, I'm sure, about that. And so-and-so drinks alcohol, and let's look at their, credit card bills and see how many times they're in the liquor store, at the pub. And that should be sufficient to either reduce or limit or restrict parenting time. What the court is saying is that you need more than that. You need to know that that this is happening when the child is in the parent's care and that they're not able to properly care for the child. So again, the court here found that there's no exceptional circumstances for supervised parenting time, and the judge put in a stepped process with a short-term supervision to move progressively back to 50-50 parenting time. So those are, I wanted to highlight those. I mean, in my practice, these are cases that come up, and I really appreciated these, the language of the courts to be very, I guess, empathetic, but also understanding the context of people who are dealing with alcohol, drug issues, and mental health issues, and not using it as the hammer when it comes to their parenting. Moving on, just a couple on spousal support. This was a case of a woman who had disabilities, and she was seeking an order for spousal support, including retroactive spousal support. She has multiple sclerosis. And just in terms of how the court, this is using the spousal support advisory guidelines. Often we just take the middle one. The court says that when a recipient is disabled, the authorities reveal a lack of consistency regarding where on the scale of spousal support advisory guidelines is to be placed and how long it should be payable. So whether it's the low end, mid-range, high end, is it for half the period of time you're together? Is it for longer than that? I think they were together 20 some years. So it's a longer relationship. Where the court in this case, Mr. Justice Punnett, found that the spousal support is compensatory and non-compensatory and ordered high-end spousal support for an indefinite period, subject to variation and possible review, and then also ordered retroactive spousal support back to date of separation. So again, this is a case if you have a client who has a disability that you can use in terms of trying to argue for higher level of spousal support and indefinite period. Another spousal support case, and I called it reduced income. It's not the reduced income of the payor, but in fact it's of the recipient. This is Stevens and Stevens, Mr. Justice Wilson. So the parties had had a trial, and the claim for spousal support had been dismissed because at the time they were earning about equal amounts of income and they had no children. So there was no there was no caretaking role. The wife was around, I think, just under 60 years old at the time this application was brought. What happened shortly after trial was she was terminated from her job. She worked driving trucks and she had a few accidents, so she was terminated. And then she moved to reopen the trial on the issue of spousal support. And the judge allowed that application to proceed. So what happened was after she lost her job, she retrained as a care aide and got a job, but it was for less money than her previous position as a truck driver. The judge found that the claimant was entitled to spousal support on a compensatory and a non-compensatory basis. So even though the spousal support claim had been dismissed, the judge did leave it open for the parties to come back. In this case, you might know, compensatory is to redress a spouse who suffered disadvantage or a payor spouse who derived an economic benefit. And so what was the disadvantage and benefit? The claimant assisted the respondent in building his business, assuming the bookkeeping role, and she's now starting again at the bottom of the seniority list as a care aide. The judge says it's not possible to determine what the claimant would have done for her career if it were not for the relationship, but I have no doubt that she would not have been 2 months into an entirely new career at age 60, and therefore there was a compensatory ground for spousal support. On the non-compensatory side, this is an important one because this is often when people talk about need, you look at financial statements and you go, as long as, oftentimes because you've seen financial statements where people's expenses are like 3 times as much as their income and you wonder how they do it. I mean, it's really hard to calculate your expenses, as you know. But sometimes then people also reduce their expenses or understate their expenses because they want to show that they're not living beyond their means or they actually have means to be able to support themselves. This is an interesting one from the judge, because the judge says just because the claimant might earn enough to cover her living expenses does not mean she's not entitled to support. Because on the need basis, people say, well, you don't need anything more. You're able to cover all your supports, right? You cover all your expenses. Well, the judge is very clear here. It's not a baseline of, can I just, eke out an existence? This is the key phrase to use in these cases. The court must seek to reduce the income disparity between the parties, and the parties should have roughly the same standard of living following separation after a long marriage. I'm citing a Court of Appeal case called Nickel and Nickel. So this is, again, a really good case in terms of spousal support for dealing with, particularly the need issue. That it doesn't just have to be a subsistence living while the other person has a really higher lifestyle. Moving further to our favorite topic, relocation. It's always fun. Relocation. These are often the hardest cases. This one's kind of a little funky. So the parties lived in Chilliwack. So I don't know if that means anything. Anyway, they had an agreement that they would not relocate without another agreement, with the children without an agreement or a court order. There are 2 kids, and child D is the younger child who's in his early teens, and there's an older child, I think like 16 or so. Anyway, the applicant mom wanted to move with the children, not just D, to Alberta. And before the matter there was any agreement or came to court, she just did so unilaterally. So there were some court cases she was supposed to bring back anyway. So, and then later on, as the court's proceeding, in the middle of things, the respondent moves to Ontario. And what happens then is there's an order by Judge Ferris that basically divided up the summer. And so the dad was supposed to have the children till August 24th, and then return the children to the mom. Well, he didn't do so. He didn't return the children when it was over. He kept the children in Ontario. So now you have a parent in Alberta, parent in Ontario, court here in BC having to decide what to do for these kids. Views of the child. This child is early teens, so views of the child matter. And so there's one that's done in, oops, I lost it. Sorry. I seem to have lost a slide. Sorry. There was an initial views of the child done by Family Justice Counselor in, I think, March or April of 2020. We're now into September here with this decision. And at that time, the child said that he wanted to stay with mom in Alberta. So later on, the father is allowed to hire privately Dr. Elterman to do another views of the child report when the child is now in Ontario with dad. And Dr. Elterman says, like most children, he wants to please both parents, but he finds himself in a position where he can't do that. Obviously, and the solution of splitting him up and having one half to mom and one half to dad is not a good solution either. So Judge Skilnick notes that within less than 5 months, the child has changed his views about which parent he wishes to reside with. And it's difficult to discern if this is a genuine sentiment or if his desire to please causes him to prefer the parent he has closest proximity to. So when he was with mom, he said, I want to stay in Alberta. When he was with dad, he said he wanted to stay with dad. This image was it was crazy to read. Justice Skilnick says, it should be noted that despite being assigned the role of the rope in a very tenacious game of tug-of-war, D presents as a remarkably well-adjusted and poised young man. I never thought about that. The children, well, we know children are in the middle, so that's an image of children as a rope in this tug-of-war. I like this line that follows. A child like D deserves cooperative parenting. Instead, he received competitive parenting. And making an order that is in the best interest of D's emotional health is best effected not by granting either of the parents their wishes, but by listening to what D has to say. Now, you remember D has said two different things over a short period of 5 months. So this is a case, just to be clear, that other than D's wishes, the parents are more or less equal. They love the child equally. You'll see, I don't have it here. Sorry, what they offer in their homes is the same or similar. So there's no sort of difference in terms of the quality of life. One of the things that goes in favor of the father is that the older brother, B, ended up living in Ontario with the father, and so didn't want to live with mom in Alberta. And so D preferred to be in Ontario with teenagers versus with his mom, because the mom had little kids. That was one. And another one was that the father was working from home versus the mom who was working out in the community. And so the father had more time to spend with the child. Now, the court did say on that matter that it's not significant enough because that could change for the father and or the mother. So the court in this case basically gave the most weight to the child's wishes, and this is in the second wish, which was to stay in Ontario with his father. One more case. I'm trying to do some out of the Lower Mainland cases. This is Madam Justice Baker and Baldas and Lillo. The parties live in Mackenzie. Now, this one you'll see that this one's a hard one. You can see why. So the parties had an agreement that intended for there to be equal parenting of a 3-year-old child. We're talking about a very young child. The mother was seeking to relocate with the child to Clinton, and the mother has a new relationship and is expecting a child with her new partner who lives in Clinton. Now, Clinton to Mackenzie is just under 600 kilometers driving. The claimant father was opposed, saying that the mother's access proposal was not workable and would result in considerably less parenting time with his son. So what the mother proposed was that the parents have 2 weeks on, 2 weeks off with the child, and that the parents drive to Quesnel to meet to exchange the child at each 2-week period. But this was only up until September 2021, because after that point, the child would be attending school. And then at that point, the mother says, well, then we'll have to figure it out after that. So Madam Justice Baker looks at all the factors. For the mom, she's on maternity leave, but she can return to her job in Mackenzie. She worked for a company, and she has no job currently in Clinton. Her parents live in Mackenzie, but they say they're moving to Kamloops, which, as you know, is, well, I don't know if you know. I'm now learning the geography of BC, which is much closer to Clinton than to Mackenzie. And the mother's partner has a good job and roots in the Clinton Cache Creek area, and his family support the relationship and met the mom and the young daughter. On the father's side, so the father hadn't been able to exercise all his parenting time because he worked shifts and started at 6 a.m. So he couldn't have his child overnight. So the mom basically kept the child overnight because he couldn't get daycare. But the father was very involved with the child's life. And also he grew up in Mackenzie and his family lives there, his parents, his brother and a nephew, and they are quite involved with the child on a regular basis. The grandparents see the child every weekend. So Madam Justice Baker steps back and says, okay, let's go through the factors under Section 69(6) of the Family Law Act, the relocation provisions. Was the mom acting in good faith? No question about that. She wanted to move to be with her new partner, and she was having a baby with this person. Was there a reasonable proposal put forward by the mom? The judge says, nope, it's not reasonable and it's not sustainable. Apart from the fact that there's a 6 or 7 hour drive and it's hazardous in the winter, which would place the child's safety at risk. Now, people who drive those routes often, who don't live in the Lower Mainland when we have little snow, might not think it's as hazardous as Madam Justice Baker does, but that's what she came up with. And that the key, though, was that the schedule the mom was proposing was only effective until the child starts school. And basically, Madam Justice Baker says, look, I've caught you out, Mom, in what you're trying to do. You're essentially wanting to defer any assessment on the parenting arrangements until then. At that point, the child would have essentially, she would be quite set, mom and child would be quite settled in Clinton as well. So she would have established a community there. So she'd have more factors that would be on her side as well. So Madam Justice Baker went through the best interests of the child, that there's no material differences between Mackenzie and Clinton for work opportunities. The move would significantly disrupt the child's relationship with extended family. Now, this is a key one about family. The new partner's family, Madam Justice Baker said, this isn't a significant factor as they are not the child's family. Now, they're important, they could be important parts, and you don't have to be related by blood or, to have a relationship or be a significant relationship to a child. But at this point, Madam Justice Baker looked at how the relationship with the father's family predates this new relationship. And that's really the critical relationship for the child, who again is only 3 and may or may not remember, I guess probably at 3, you have a really good memory and of your family, the people who are around you. The judge did acknowledge that the mother's emotional well-being would be affected by the decision. It would be affected by any decision if she had to stay in Mackenzie. But the judge noted it was her decision to become involved with a new partner who does not live in Mackenzie. And that's what created the difficulty for her. And in terms of the child, there's no evidence that the child is unhappy in the present environment, living in Mackenzie. So the judge ordered, I don't know what, I think I was going to go, here's the answer. The judge ordered that the parties share parenting in Mackenzie and denied the application to. I want to move on to, I got to move faster. Justice Baker again on an annulment case. So in this case, the claimant was seeking an annulment versus a divorce due to her faith. And as you know, annulments render a marriage voidable. So the ground for the annulment was that the respondent husband was impotent. And the test is whether one or both parties is incapable of engaging in sexual intercourse due to a physical or psychological incapacity. And that incapacity has to be from the time of the marriage, not just during the course of the marriage. So to warrant an annulment. So that's what that says there. The respondent could not the respondent could not maintain an erection. The parties hadn't lived together before marriage. So at marriage is sort of when they then started to have sex. One doctor did a blood test and couldn't find anything wrong with the respondent. The respondent didn't want to go and get other tests to see what was going on. The respondent said, well, after they separated the parties, the respondent says he has a new girlfriend and they have sexual intercourse regularly. Although Justice Baker noted there's no evidence from the girlfriend at all about that. What's key, though, in this is that impotence does not need to be a general incapacity, but can be in respect of the particular spouse only. So just because the husband was able to have sex with some other woman didn't mean that annulment wouldn't be warranted in the case with his wife, because it was clear from the evidence they tried to have sex like every several times a week, and then just before separation there was like 4 or 5 times a week and so forth, and he could never do it. So the annulment was granted to the claimant, and she also got her costs. Some of the cases on property, and things haven't sort of changed in terms of this whole notion of gift or loan, the whether or not you lose your exclusion if you put property in the joint names of the party. You do, essentially, although some judges are still kind of trying to pull it back out and use unequal division of property to give people back some of their exclusions. But I'm just going to focus on a few of the reapportionment cases that have come out this year, end of last year. And so I'm going to start calling it reapportionment. The first one being this case called James and Chase with Mr. Justice Verhoeven. So the husband was arguing that the wife had reduced the value of the family home. And the provision he was relying on was that a spouse, other than one acting in good faith, has substantially reduced the value of the family property. So they owned a big property outside of Prince George, and this was their only substantial asset. And the husband sought an unequal division because of the damage that was done due to the wife's operation of a cat rescue for some years in the home, with up to 40 cats living in the house. And the husband said that the damage essentially caused the damage caused by the cats diminished the value of the house by $100,000. So the key in this case is other than acting in good faith. And lack of good faith could cover a wide range of behaviors. So, for example, if you're living in the house and the furnace blows up and you just basically, or the water pipes, or you don't do anything and the water pipes freeze, for example, you're in Prince George, right? Although apparently it's going to be a lot lower temperatures this year. But anyway, and you know what you should do, but you went, no, I'm not going to do anything. I'm going to basically burn this place to the ground by letting it go downhill. So you don't actually do what you need to do to ensure that the pipes don't freeze, and then the pipes burst and causes all this damage, reduces the value of the home if it doesn't get fixed, and so forth. That would probably be known as bad faith. If you let your buddies come in and just party and spray paint the walls and urinate and poop on your furniture or whatever like that, that's probably a lack of good faith. In this case, though, Mr. Justice Verhoeven says While the court could infer from the evidence that the situation with the cats arose as a combination of poor judgment on the part of the wife, together with emotional and psychological factors of some sort resulting in poor decision-making. However, this was not enough to show that the wife lacked good faith in what she did by having cats there. And therefore, this provision did not apply, and the property was divided equally. As you know, another word for reapportionment is significant unfairness, Section 95. So I'm just kind of using all the words that get used. So this is a case of the Court of Appeal. And this is often what people talk about, is that they pay the property tax, the mortgage, the insurance, without the contribution of the other spouse. And so they want to be compensated for it. In this case, the wife had paid those expenses for 2 years after separation, but she also had sole occupancy of the house during the whole time. On appeal, the wife argued that essentially awarding equal division amounted to dividing the family debt unequally, because she considered the mortgage payments, property tax, insurance, all that sort of part of the family debt. And that meant she had to take all of it, right? The Court of Appeal did not accept her characterization of those expenses as family debt. The court then also held that equal division of the property was fair, given that while she paid those expenses to maintain the house, she did not pay any rent to the respondent, and he had to provide for his own accommodation. So some of this also comes into when we do the occupational rent arguments, right? Where somebody is seeking to be basically compensated for one party living in the home while the other party has to rent accommodation. So this is a good case for if you are trying to argue that a party shouldn't get money back from mortgage, property tax, or insurance. That said, if the mortgage, property tax, insurance is probably a lot significantly more than what is paid for accommodation, the courts oftentimes will see that as an unfairness and order, for example, that the non-resident spouse pay some of the property tax or mortgage or insurance. Because, of course, the servicing of the mortgage, property, and paying property tax and insurance, if property increases in value due to market forces, the spouse who's not living in the home also benefits from that. So benefits from, in this case, the claimant maintaining the home. So that's another case that's a good one for significant unfairness. We move to, yes.
There's been a couple of questions come up. I thought I'd try and ask you now, rather than leave them to the end and make it more hard. Someone was asking about, in the case with the annulment, why the person was given costs, because she doesn't hear that very often.
I don't know either. I know Madam Justice Baker. I was going to ask her the other day. I don't know why, because the reality is it's something that the other party can agree to, right? So it wouldn't be. It's not a case where I suppose it's because of how he fought it. So he didn't say, "I take no position, except that," because I'm only reading the decision, so I don't I don't know what the evidence was led or how hard he fought it. Or it could just be that if you're successful in your application, the general practice is that you're awarded costs. So that, costs follow the result. So that could be it. There's no actual particular comment about it. I just thought it was funny that the costs were awarded. So, but this was not a case where, as I said, that a party, the husband could have, I guess he could have just said, "I take no position." It's not like they could have come to consent order and granted an annulment. The court has to make that determination, just like they do on a divorce. You can't consent to divorce. It doesn't matter if you consent to divorce. Yeah. So I will talk. I'm going to ask her on the side why, but it may just be costs follow the result.
Okay, there's one other question. This was a ways back.
I'm not hearing you well, Lois.
Oh, do I still sound like a robot?
It does.
Okay, you know what? I'll leave it and come back to this question later.
Okay. Did you want me to? Oh, I have nothing to read. I see. Okay. Yes. Okay. And then another term for reapportionment, significant unfairness, is unequal division of property. And this is another case out of the Court of Appeal called Singh and Singh. And the court was considering in this case what falls within the ambit of the term of the provision 95(2)(I), which is any other factor other than the consideration referred to in subsection 3, which has to do with spousal support, that may lead to significant unfairness. So this is the court is saying any other factor doesn't mean anything, right? The court actually goes through sort of Latin terms and stuff like that. But in this case, I'll get to that. The trial judge found that the trial judge allocated an additional $250,000 to the wife on top of it. So started at equal division and then gave the wife an additional $250,000 pursuant to this section 95(2)(1). After taking into consideration the husband's bad faith conduct in relation to his bankruptcy and his lack of disclosure surrounding his assets in India. So the Court of Appeal was then tasked with considering what factors are properly the subjects of 95(2)(1). So the court in this case, the Court of Appeal, concluded that the scope of 95(2)(1) can be any factor that may lead to significant unfairness, but it's rather a limited class, namely the economic characteristics of a spousal relationship. So this means that certain conduct is not, if someone has an affair, right? Any other factor doesn't cover, you had an affair, I should get more of the house. And you know how many of our clients like to say that. So this is the Court of Appeal saying, yeah, that's not one of the any factors. Okay, it has to do with the economic characteristics of the spousal relationship. They don't define that further, so I'll just leave it with that. They refer to another case of the court, Jazuska and Kostansky, where that they noted it's a limited class, and in that case, it allowed for the relative contribution of spouses to the acquisition, preservation, maintenance, or improvement of family property during a relationship. Because under the previous legislation, you could consider a party's contribution to assets in terms of whether or not it was significantly unfair that they either didn't get a share of the property or they had to share it equally. So in this case, it says, yes, that falls within the contributions of party, because it's not, that contribution of party is not a specifically itemized term in 95(2). But the Court of Appeal found that it does fall within this broader category, limited but broader category 95(2)(1). In terms of the two factors that the trial judge was dealing with, so the bankruptcy plus the failure to disclose, the Court of Appeal also said that the limited class would clearly encompass the existence of undisclosed assets and the cost of bankruptcy and a party's motivation for entering bankruptcy. Basically, he was trying to, he didn't care if he screwed himself, he was also trying to screw the wife in terms of seeking a bankruptcy. But this is a key one, I think, as well, is that includes the existence of undisclosed assets, right? So if you can't determine the assets, it's sort of the case called Kunha, where, disclosure is the scourge of matrimonial property, is that, parties are required, as you know, under the Family Law Act to disclose. And if they don't, the court can find, using this section, a way to unequally divide the assets. The court also found that bankruptcy could fall under 95(2)(f), which has to do with post-separation reducing the value of property or increasing debt of property. I'm not quite sure how bankruptcy follows in that, but anyway. So in this case, the Court of Appeal upheld the trial judge's determination that an equal division of assets would be significantly unfair and allowed the unequal division to continue. There's a case around excluded property I just wanted to touch on, and this is regarding a personal injury settlement. So most of the time we talk about excluded property as what? Property you bring into the relationship, inheritances, that's a big one, right? Those are the two main ones that we often deal with in terms of do they maintain their character as excluded property through the relationship. So this one I just want to touch on. It probably makes sense to you, and it's not necessarily common, but there's some comment about personal injury settlements. So as you know, what is excluded in a personal injury settlement is anything to do with pain and suffering. any part of the settlement that has to do with lost wages is family property. So it's not excluded. So there's two components of a personal injury settlement. The reality is, any of you who've, well, I haven't received any money under personal injury settlement, but I'm aware that oftentimes you get a global sum. Here's the amount. And it's not broken down as to how much is your, for lost wages, if anything, how much is for personal injury. Now, if you're not working, if you, for example, were a stay-at-home mom and you're working, sorry, you're not paid for that work, then it's unlikely you would have lost wages included in that. So it's easy to say that all of it would be personal pain and suffering, and therefore it would be excluded. In this case, STC, the spouse, the court makes it clear that the spouse who's advancing the excluded property claim is the one who's responsible for demonstrating that the property is excluded property. In this case, the respondent, he was unable to demonstrate that none of his personal injury settlement was attributed to lost income. And that's key, none of it, none of it. I mean, it could have been $1, but as long as, if he can't prove that, he also had no documentary evidence to support the tracing of the settlement funds. So he, apart from you have excluded property, then you need to see what happens to that excluded property to see whether or not it maintains its character as excluded property, right? And this is where we get into, if you take your excluded property and give it to your spouse, or you put it into the joint account or the joint property, your home, you lose your exclusion, right? If you spend it all, you lose your exclusion, right? So in this case, that's what we call the tracing. The respondent wasn't able to show any documentary evidence of how that money that he says he got in the personal injury settlement traced into any other property or what was done with it. He had some receipts, and he had his own oral testimony, but he couldn't show where the source of funds were for those receipts, for example. And he was fairly vague, I understand, in his oral testimony. So in that case, this is an important one to note, is where an excluded property claim depends on a person's oral history, oral evidence, and it's unsupported by any independent documentation. That evidence must be scrutinized for reliability and credibility. And so credibility of a party is very important. And in family law, it comes out a lot where the court says, if there's a contradiction between the versions of facts by the two parties, I prefer the evidence of X over Y, right? Credibility is very important. You don't have to, the court doesn't necessarily have to slam and say, this person is not credible at all, I believe nothing. But if there's points in which the court finds there's some lack of credibility, it can affect the claim for excluded property in this case. And why this is important where you have to have oral evidence is, if you think about it, remember when they changed the Family Law Act in 2013, well, people had already been together for a long period of time. And if they had excluded property, i.e. property they owned before the marriage, you're not going to have documents 20 years back. You just can't get them. So you're relying on oral evidence of people saying, well, this is what I had before and this is what I did with it. And so if the court can believe that person, then and the other side perhaps doesn't contest it as much, says, oh, I know that he had some money before, she had RSPs before, then the court will accept the oral evidence. But generally, they want documentary evidence if it's possible. So in this case, where the respondent wasn't able to establish that the settlement does not include lost income at all, then the result is that no part of the settlement is excluded from family property. So even if the respondent said, well, of course there's probably 20,000 of my 100,000 that's probably lost wages, like I was working at that time, right? The court wouldn't have been satisfied with that evidence, and then said, so if the respondent could establish that there wasn't any lost income at all, there's some lost income, that all of it was in, right? Not just the 20,000. I'll accept 20,000. Take 20,000 out. No, all of it's in. So I'm not sure how often this case comes up, but it was an interesting one for me to look at around exclusion and personal injury settlements. Moving on, I want to talk, the next few cases I want to talk about deal with evidence. And And this one is from Madam Justice Francis in regarding the evidence of children. And in this case, it was a relocation case where the mom wanted to move with the children back to Bulgaria, where the family had all lived before. The father had been charged with assault and he pled guilty, and he was on a conditional discharge with 1-year probation. So the question here was, there was no views of the child report. I'm not sure why. I think it might have been cost for Section 211 report. But the question was whether or not the 12-year-old's evidence coming in through third parties, in this case it was a counselor and a social worker, would be admissible. And the court found, because that's hearsay, as you know, the counselor and the social workers testify or giving evidence. The court found that this was an exception to the hearsay rule. And the court was satisfied that hearsay statements were necessary in determining the best interests of the children, and that they are reliable evidence that TR has been subject to family violence at the hands of his father. That was the evidence of the counselor and the social worker. The court had to consider the child's statements in the context of his personality, intelligence, and understanding. And the court found him to be mature and thoughtful and sensitive to preserving a relationship with his father. So the court was able to surmise that it wasn't about the truth of statements, but more that the child who was 12 understood what he was saying, why he was saying it, and also it wasn't being done to essentially punish his father. But he was, and so the court found that to indicate that the statements made by the child through these third parties were essentially truthful as to what was going on. It was credible. So Madam Justice Francis found there's credible evidence of the children being exposed to family violence. And that was a key factor in determining whether or not the relocation was granted. Apart from the fact that the mother had family in Bulgaria and had work available to her there as well, and that the children did want to go, or the older one expressed he wanted to go. So in this case, the relocation application was granted. So this is just one about, if you have to bring in evidence through a third party through children, then you consider the context. Think about, how mature a child is, thoughtful, perhaps have the person who, they're not giving opinion evidence, but maybe in their statement, they make some comment about how the statement was made to them and their thoughts on the maturity and level of understanding of the child. The provincial court is pressing for the use more of the children's lawyer, which will be probably very helpful in some ways of finding another way to have children's evidence put in rather than through third parties like in this case. This was an interesting case about questioning of self-reps. It went to appeal. It's called Brown and Brown. And the appellant argued that husband argued that the Chambers judge had erred by posing questions to the respondent, who was self-representing herself, and during her submissions, and then accepting unsworn evidence from the respondent, both in answers to questions and in the course of her submissions. Now, I can tell you as counsel, when you're dealing with self-reps on the other side, and they're just essentially giving submissions, they're giving their evidence as well. And you stand up and say, that's not in evidence, that's not an affidavit, that wasn't testified to, for example. So the court, of course, has to be mindful of being fair to both, to the process, to, for example, my client's case, but also to the self-represented person, right? And sometimes, to be frank, I think they go overboard in supporting a self-represented person because the court doesn't help me and ask my client the questions that the court wants to know. The court relies on me to do that. And sometimes I'm not quite sure what the court may want to know or doesn't understand, or I haven't asked the question well enough. But then when the court asks the respondent, the self-rep person, all these questions, it helps fill in their case where that person hasn't done so. Anyway, I dealt with that in one case and it was a bit frustrating. But anyway, in this case, the Court of Appeal dismissed the appeal and held that there's some scope for admitting unsworn statements into evidence, and that even though acceptance of inadmissible statements into evidence constitutes an error of law, it will not be found a meritorious ground of appeal unless it's shown that the inadmissible evidence may have affected the judgment or that it rendered the proceedings unfair. So even if it's allowed in, even if the judge has it in his or her mind, as long as that's really not what grounds the outcome, then it won't be enough to overturn that decision because it doesn't render the proceeding unfair. And again, the court said that, as I said, when dealing with self-represented parties, the court must strive to ensure that the hearing is fair to both parties. A judge may properly ask questions to ensure that the self-represented party is afforded an opportunity to present their case, but the judge may not make determinations in absence of evidence or act on allegations that have no evidentiary value. What is important is not whether a party says things beyond admissible evidence, but rather whether the judge made improper use of those statements. So it's important, I still think that if you are, well, if you're counsel, or if you're acting or supporting a client in court, is that they still make the objections to when, if they hear something that they know is not in the evidence, that they make the objection. So it puts the judge on notice that this isn't in evidence. This is just somebody speaking. But it's hard to kind of remember all that might be in evidence or not. Sometimes you don't remember. But anyway, so it's not improper for judges to ask questions of a self-represented party and or a party who's represented by counsel, but they often ask less questions. But it is imperative that if you are represented by counsel, you're the other self-rep, that you be mindful of what might end up in the decision and whether or not it's grounded in admissible evidence. Another one of evidence I wanted to just touch on was regarding recordings. This is Mr. Justice Skullroot in a case called AJF and NLS. This case was just like crazy. I think there was like, I don't know how many affidavits for it. It was a huge amount of affidavits. It was very high conflict, let's say. So the claimant was seeking to address what he characterized as the respondent's repeated, prolonged, and unrepentant failures and refusals to abide by multiple court orders. Those orders were around child support, the payment of the Section 7 expenses, the cooperation with the 211 report writer. And the judge said, this is how bad the case was, to say this is high conflict does not capture the degree of toxicity that has pervaded the lengthy history of this litigation. Yikes. Anyway, the judge noted that many affidavits of both parties are replete with hearsay, opinion, and argument. Much of the evidence and submissions focused on excavating their history and relitigating past grievances. So that's the context of it. One of the issues that came up was the claimant was unhappy. There was a objection regarding the claimant was unhappy that the police was not enforcing on it. The Crown had declined to charge the respondent for the breach of the protection order. And so the claimant, So the claimant then surreptitiously recorded the conversation with Crown and then sought to introduce the transcript into the proceeding. Well, Mr. Justice Skullroot was not impressed with that, and he disallowed the transcript, and citing a case called Lin and Huang, which said that the practice of recording personal conversation for use in family litigation is insidious and should be discouraged. That said, I have used recordings, particularly not as much of the parent to parent, but also the parent with child. And you do have to be cautious about that and see what you're trying to prove or not prove. I mean, courts will take them with some skepticism because, of course, generally when we're sticking in either the transcripts or the actual recording themselves, and courts will hear them. We're not necessarily hearing the whole recording. Our client hands it to us and we put it in. You don't know the context. You don't know what preceded the recorder being started and what happens afterwards. So the reliability of recordings, the authenticity of recordings is obviously in question. In this case, I think it's the recording of Crown counsel. It's like recording a lawyer. The court was not impressed by what the husband had done. And the court said the claimant couldn't explain or justify recording Crown counsel. And the court stated that to do so as in to record Crown counsel and then propose using the recording in this proceeding shows remarkably poor judgment. And we go back to credibility. And so doing some things like this in the minds of the judge will affect how the judge views this party's credibility. So when you are working with your clients, you need to be very cautious about, let's just throw all the text messages, let's throw all the recordings in. You have to be thoughtful as to why you would be putting a recording in or putting all these text messages in as well. Okay, so I think I have one more on, no, we're moving to enforcement. This is my last round of things. Enforcing compliance with orders. So Section 230 of the FLA, it's a provision that applies for the purpose of enforcing an order made under the FLA if there are no other provisions in the Act to enforce the order. So example, Section 188 applies to the enforcement of protection orders. So you can't use Section 230 to enforce a protection order. And also for conduct orders, Section 228 also has built into it the enforcement. So you can't use 230 to enforce a conduct order. So some of the remedies that you can get under Section 230 is to require a party to give security and inform, require a party to pay for all or part of the expenses reasonably and necessarily incurred as a result of the party's actions, including fees and expenses related to family dispute resolution. And I think I've previously talked about this where, although I've only seen Judge Challenger use this, not this particular one, but a similar provision in other in 221 and probably 228, which is that she's ordered a party to pay some or all of legal fees that are incurred by the party for their breach of either failure to disclose or their breach of orders. The court can also require a party to pay an amount not exceeding $5,000 or pay a fine not exceeding $5,000. And I was forgetting about that. A fine is paid to essentially the government, right? So if you're seeking any, you want the penalty of $5,000 so your client can get it. This is a case, Ho and Chu, Madam Justice McDonald, and this was regarding a claimant's failure to comply with a master's order to jointly retain an expert to prepare the Section 211 report. The parties were to retain Dr. Michael Elterman. The claimant did not want to do so and in fact proposed another Section 211 report writer. And then later when I think the husband had agreed, the wife said, no, I don't want that person either. Anyway, in addition, the claimant refused to engage in the process altogether by failing to schedule appointments for herself and the child or to pay her share of the retainer. In this case, the court, Madam Justice McDonald said, I'm satisfied that Ms. Ho has acted in a manner that frustrates the court-ordered Section 211 process. The court can order a fine to enforce a court order. At this junction, I'm not prepared so she's equating fine and penalty. I'm not prepared to order a $5,000 penalty for Ms. Ho's noncompliance with the Master Boss order. I'm prepared to order costs of this application against Ms. Ho to be paid forthwith. This is more appropriate for a first-time breach. So costs in the Supreme Court, as you know, sort of is based on a table. So each half a day of hearing is worth $1,000. And then there's some disbursements you can charge for. So that's kind of the cost that would be awarded. If it was a full day, it'd be $2,000. Of course, as you know, in provincial court, there's no provisions for the order of costs. So I think you could take this kind of case and say, look, a court finds a breach of Section 211 or not cooperating with a Section 211 report writer constitutes a non-compliance that should be penalized somehow. But in the Supreme Court, Madam Justice McDonald said, well, we've got a cost provision, so we're going to use that. If you're in provincial court, I think you still can use this case, but then say, since costs cannot be awarded in provincial court, unless you consider that 230 to be where you can have broader like payment of fees, that you're seeking that the court order, for example, the payment of fees or payment of up to $5,000 to your client. So that's how I would use this case in both, the Supreme Court and also provincial court. Lastly, the judge wanted to make clear that court orders are serious and cannot simply be ignored. Compliance is not discretionary. The importance of complying with court orders is fundamental to the proper administration of justice and the maintenance of rule of law. And that's from a recent case, AJF and LS. So again, if you are going in to argue that failure to comply with court orders should warrant the payment of a penalty or fees beyond just a $5,000 penalty, again, you can use this case, which again, a number of cases will stress court orders. I mean, most judges know that. But at least you have another case you can rely on to seek payments and penalties. And that's it for me in terms of the points my talk for you today.
Nicely timed.
I was slow in the first, and then I was like, okay. But anyway, I hope I covered a lot of. I mean, there's always other things to cover, and I try to do. I don't know. I use my judgment, and I apologize if maybe next time people will write to me and go, I want to know more about this. I did sort of look up things like Section 89, which is getting an advance on assets. There wasn't anything that exciting there, or Section 91, the restraining orders again. So I didn't find any really good ones on sort of denial of parenting time, except under the COVID era, there's a few. But so that's kind of why I picked the ones I picked. Because I thought they were. It's not that there are lots of cases and there's things you can pick out of everyone, but I tried to pick something that I thought might be of interest to folks. I try to get into your heads. Sorry if I don't quite get there.
No, I think that's good. It's more interesting than the plot on some of my Netflix movies. The facts are odd. Yeah, there was one other question, but it's disappeared. It was about the case where the woman asked for spousal support after she lost her job. Right. There was a question about how long they'd been married.
I can't quite remember, but it was 20. Yeah. It was over 20 some years. I think it was a long marriage.
Okay.
Yeah.
Okay, that was the only other question that was there. Oh, now we're just getting people saying, "Thank you for the presentation." I mean, not just. So there you go. So thank you, Agnes. If you can. Oh, there's a Q&A there popping up. Just a second. No, wait. No, there was a question. No, that was just the question before about cost for the annulment.
Okay. Well, if we were in person, I would be asking you all questions. That's what I always try to leave room because I always love to hear from you folks. So, and experiences with things. I mean, I always appreciate your smarts. I mean, I learn a lot from you folks. So anyway, that's the part that makes me very sad today.
So there are two more questions. Well, actually, someone has not asked a question, but Nikki, I'll find you. There's a question about FMEP, but then someone else has asked, in your experience, can the FLA trump the CFCSA when there's a clear Section 13? Boy, sounds like code.
It's totally code. So whether or not Section 13 being, the protection grounds, essentially no, only because the family law judges will not do it. If there is a child protection issue, the judges under family law case will essentially defer to the ministry until that's dealt with. Unless, of course, the ministry is okay with it. But if there's any opposition, I mean, it depends what the family law case is. Obviously, you're probably talking about a case where the parents then, if one parent isn't allowed to see the child and the other parent says, oh, I'm going to allow that parent to see the child, the judge won't do that. I mean, where there's a lot of controversy, as you know, is when the ministry kind of threatens one parent to say, if you allow your ex to have parenting time with the child, we're going to come and apprehend. Except they won't sort of formally start a child protection proceeding or do a safety plan. So then, it's mostly the woman goes in and tries to tell the court, well, this is a case where the other parent says, well, you're wrongfully denying parenting time. And it's very difficult to muster the evidence that the ministry is saying, if you don't keep the child away from your ex, then we're going to step in, right? So the judges are kind of in a weird place because the judges then don't want to enforce the order for parenting time when it may be that the ministry then will step in. So they generally sort of back out and say, we'll wait till the ministry thing is kind of settled. So they're but if you had for a case where it's a family law proceeding where, this is where it's interesting because I have a case like this where the grandparent wants to step in and seek guardianship or contact with the child and sort of basically to have the child in the grandparent's care. but outside of the ministry. They don't want the ministry involved. And the ministry is involved with the parents somehow. Whether or not the judge in the family law proceeding will allow the grandparents, where there's no protection concern with the grandparents, to take essentially care or custody of the child. So, and because, grandparents could get involved with the ministry side and probably have the child placed with them. But as you know, many people just don't want to be involved with the ministry at all. So I'm not sure in that case I can't see the reason why the judge can't make those orders. It's whether they will, is really it.
Okay, thank you. Now, another question. When you were talking about schools and COVID, someone's wondering whether the same would apply to preschools. Same principles, I guess.
Yeah, I think so. Yep.
Okay.
Yeah. I mean, well, actually, I don't know. Actually, sorry, I shouldn't say that. Have the health authorities, has Dr. Bonnie said things about how daycare should be operating in terms of in a COVID era? I mean, the reason why is because schools have there's supposedly this whole protocol around schools. So as long as if it's protocols around preschools, then it would be the same. Essentially, the courts would defer to, if the government says it's safe and you can have it there, and then subject to a child having higher risk or a family having higher risk, or other things like parents, needing daycare, essentially preschool to be their daycare. The courts will consider those as well. So I think it starts with, have the health authorities or government put enough things. So I don't think you could just leave your kid at a restaurant or a pub these days. So I don't think those will count. Those won't work.
The question about FMEP, someone's heard from FMEP that they will not be pursuing court applications to recover costs from payors during COVID. Sorry, the question jumped out of my screen. Oh. Is that true? Oh, they won't be pursuing costs from payors due to COVID. Do you know if that's going to be resumed or if it's?
I don't know, actually. You mean costs as in?
I guess maintenance that they owe.
Oh, arrears. So not actual, costs for proceedings.
Yeah, no.
I think at a time that FMEP sort of went tools down for sure during COVID, because they realized that if people aren't working, they're not going to really be able to go after them. Mm-hmm. I hope that they're now starting up again. But I can call my buddy, Paul Hundel, who's a lawyer for FMEP, and ask him. But I'm guessing that they would have stopped because it's really was not worth sort of trying to chase people who, were already having such difficult times. I mean, if they lost their jobs and that sort of situation.
That may be something we can ask the provincial guys when they turn up.
Yeah. Okay. I mean, usually in cases like that, I would have, if my client was the payor, I would have my client contact or write a letter to FMEP explaining the situation, and basically asking them just to put the brakes on it. So I don't know if they had just a blanket policy that they weren't pursuing people, or they weren't if people were sort of saying, coming back to them and saying, look, I just lost my job and I have no way. Actually, initially, nobody had a way to actually try to vary the order or agreement. But I think now that we're back to the place where you can now seek to vary the orders, then I think that FMEP should be stepping back in. Mm-hmm. But yeah, let's ask the provincial guy. Let's do it.
So just following up on the FLA MCFD, the person is saying that it was the father who had the FLA order and MCFD followed it, but they didn't care about Section 13.
As long
as unclear?
Is it because the child was with the father and the father was able to keep the child away from the mother with whom MCFD would have protection concerns?
I don't know. And if we're checking,
in those cases, oftentimes then MCFD steps back because they say, well, we don't need to pursue our process because the child is safe. We don't have a protection concern with the father. And if the father is able to, because of the court order, keep the child from the mother, with whom MCFD has a protection concern, then MCFD doesn't have to step in. So the protection concerns remain around the mother, but if the father is able to keep the child. That said, like if you have a case where it's supposed to be shared parenting and the father is quote unquote wrong, like really denying parenting time, and then we go to court over that, there's got to be something more. Like the father is denying parenting time and will argue at court, if challenged, that it's not wrongful withholding of parenting time because the ministry is involved. And that's where it gets tricky, because if the ministry says, well, we are not, there's nothing to do with us, or we're not telling you anything. Yeah. There's the very gray areas about what is Section 13 concerned sometimes. So.
Okay. Okay, more slightly detailed questions. There was a husband and wife in an accident, and the husband was disabled. He received a settlement from her insurance and used the money to buy a home and a vehicle. And later the marriage broke down. The question is whether she's entitled to half the home and vehicle that he bought using the settlement money. So
that's so like tricky. It's got lots of elements in there. So the home, you say the home and the home and the vehicle?
Home and a vehicle.
Okay. So one thing with vehicles, of course, is they depreciate in price, so in value. So it depends sort of how far along you are. It may have little value at that point. So what would be, if the property was bought in joint names, the exclusion is generally lost. So even if it starts as excluded property, but if the house is bought in joint names and the vehicle's registered in joint names, generally the exclusion is lost. Okay. If the proceeds were being used and from the personal injury settlement, the settlement to buy the house, and it's not necessarily in joint names, or there's an argument about that, you do have to then figure out what of that settlement was lost wages versus personal injury, the pain and suffering. The lost wages part is not excluded, so the wife gets half of that, and what it increases in value, which then it gets really messy. But as the case that I was saying to you, that if the husband can't show what part is lost wages, the presumption is that all of it's lost wages, and you lose your exclusion, right? So you have to be able to show that. And one way, because it's hard, because oftentimes you get a settlement, it's a global settlement, and you don't know, it's not broken down. So I've said this before, is one way you can do an estimate of that is that if there's ever been an offer to settle. So let's say you ask for $100,000, and in the offer to settle, it says, and 25% is lost wages and 75% is pain and suffering, right? Mm-hmm. And then the settlement comes back at, they give you $80,000. You can still take the percentages that were in the original settlement to presume that, therefore, of the $80,000, 25% is lost wages, and the remaining 75% is pain and suffering. So you could do the math that way. If you have that kind of evidence, at least that would give you some basis in which to argue that that was what the intention was. Mm-hmm. So again, that's a bit of a documentary evidence. Yeah.
And depending what the title is.
Yes, depending on the title, of course. Yeah.
Okay. I think we just got two more questions. So I'll just, oh no, maybe not. Maybe they're sliding in. The parties had an agreement at separation not to pursue any further money other than the house split. Mm-hmm. The wife is now wanting spousal support. She earns less than the opposing party. She is disabled with anxiety and depression. She didn't ask for support originally because she felt guilty about having an affair. So now, can she ask for spousal support now?
Yeah, I mean, essentially, you're seeking to set aside the agreement, and so, I mean, parties. There's always like a term in an agreement that basically says the parties understand that the courts can intervene if they find that an agreement was unfair at the time, or unfair at the time of signing, or unfair at the time of when an application is made to set aside an agreement. And so you're not always off the hook. That said, a court will hold parties to their agreements as much as they can. So in her case, if she became disabled after, she would probably still have a pretty good chance to set aside the agreement if she has nothing else, right?
If it was a changed circumstance.
Yeah.
That was
That could be one. Or if she could argue that she was, it was undue influence or something, like maybe apart from the fact she had an affair, but maybe the husband made her feel like crap about it, and really sort of pressured her to accept it. Or, if you don't take this deal, I'm going to tell everyone in your family what a blank you are, kind of thing. That could be an argument for that. But setting aside agreements are difficult. They're not the easiest things to do. But the courts also recognize that, in particular with long marriages, that, there is a social contract between parties who marry, and the state should be less involved in having to compensate.
okay. Last couple of questions. If someone's just asking if FMEP can be claimed against things like CERB, EI, the Canada Recovery Benefit.
Any kind of income they can. I think anything you get from government they can attach to.
Can still go.
But they allow people to have a certain amount of income, so they only take they take percentages. This is like when they garnish your wage, they don't take everything, even if you owe a lot.
Right. Yeah.
Stop percentage. Like they don't take everything. Yeah. But yeah, they can attach to those if it's federal monies.
And the final one's a philosophical one. Your opinion about the upcoming changes to the Divorce Act?
Well, I mean, it's kind of they model a lot what's in the Family Law Act. So it'll be nice not to have to talk about joint custody and guardianship. I think it would be horrible if it was totally different. I don't know whose legislation is totally different than ours, but I don't know. I mean, I think that's helpful because, in BC now, you always have to decide whether or not you're making orders under the Divorce Act or the Family Law Act. And going forward, particularly in parenting, it won't make as much of a difference because the language will be the same and the concepts will be the same. Interestingly, the Divorce Act still has the maximum contact principle, which doesn't exist in the Family Law Act. I'm not sure. I don't know the discussion of that. So that still creates a bit of a distinction between the two legislations and stuff like that. That said, I mean, the Family Law Act is based on it's important for children to be able to have meaningful relationships with each parent, which you could kind of read into that. There's a maximum contact principle notion, right? So, but yeah, I haven't, I'm going to listen to JP's, I should listen to JP's presentation, which will be exciting.
Yes. Yeah, everybody, if you're, they know. There's Divorce Act coming up on Thursday.
Yeah, Thursday. So. But he's the guru of divorce. So I think it'll be good to have sort of more consistency across the legislations for us. I mean, the things on child support and spousal support doesn't really change. It's the parenting things that will sort of more mesh with our legislation. So it'll be easier in that case for us, I think. I haven't sort of looked at where the distinctions are in that. Yeah. Okay, look, just right bang on time practically. So thank you all so much. I'm just looking at all of you. I'm trying to look at you folks. I really always appreciate all of your work, all that you do. You guys are the best.
Well, lots of thank yous.
Thank yous.
And really appreciate it. Next year we will see each other in person.
Yeah, I hope so too. Next year, right?
Yeah, definitely.
Back to the Radisson.
Back to the Radisson. That's right. Okay. Thank you, everyone.
Take care, everyone. Be well, be safe.
Bye.
Bye.